afterwards. Ari, thanks for reminding me.
No problem.
I would say not at this moment since you didn't, but I did remember. So let's just keep going. So what we're going to talk about today, and again, I welcome everybody to this opportunity, and we appreciate you guys taking the next 45 minutes to be with us as we talk about case processing reforms. So in 2017, the Casey Foundation published a practice guide. Bart, is that right? A practice guide? Is that
correct?
Okay. Timely justice about case processing reforms. Then we mobilized around that and created this community of practice. And a community of practice is simply a community of people that came together, hey Nancy, on JDAIconnect and worked for a year and a half, 9 sessions. And we worked on how could we in our sites improve case processing reforms. We chose that first one. I'm going to let Bart talk a little bit about why we picked case processing as our first adventure into the community of practices. But we've had 8 sites join: Dallas County, Texas, Douglas County, Nebraska, Hawaii, Milwaukee County, Wisconsin, Philadelphia, Pinal County, Arizona, Rankin County, Mississippi, and Shelby County, Tennessee. So they all formed teams. They came together, and we met over that period of a year and a half to get together and to learn more about case processing reform. We decided we wanted to figure out ways that we could share the information from that experience. And so we gathered some of our members and one of our faculty to be our featured guests on this Brunch and Learn. So I don't know how your cameras are looking, but the distinguished gentleman in my top right, whose name is Bart Lubau on the screen, was one of our faculty members in the community of practice. And then Shelley Seltzer from Nebraska, Shelley wave, and William from Hawaii, wave. And then we also have Amy on. So Amy, go ahead and wave because you were also a participant in the community of practice from Shelby County. Shelley was from Nebraska, and William unless I don't know something, but William is from Hawaii. So we'd ask them to also, kind of be the featured speakers and just telling us what their sites gleaned from the community of practice, and also maybe if they have any results they could share. So that's what we're going to do. Is we're going to brunch, and we're going to listen to our guest speakers. I'm going to do very little talking once I get done here in the beginning. But I just kind of wanted to just say again, the benefits of this whole experience of Brunch and Learn is it provides this networking opportunity. And that's why, to the degree that you can have your camera on, be on camera with us. Hi, Tashai, how are you? We can see people, we can wave, and we want people to get to know each other. And this is a great way to do it, right? To network. So I was
going to say, face. Yeah.
What, Ari?
I was just saying you could put a face with the name. That is super helpful. Yeah.
Exactly. And then that's why I was about to say, like, if you don't have your names on your thing, your camera, how to change that, but everybody's got their names on, so I don't even have to say nothing there. I just wasted a whole 10 seconds. And then we want to hear from our featured guests, and then thank you, Nick. Nick loves this. Nick, did you mean you love me, or you love the whole thing, or both? Both. Beautiful. Lots of love there. And then at the end, then we want you guys, not at the end, but this isn't a webinar, right? We purposely didn't design it as a webinar. So you got a question, raise your hand, take yourself off mute, ask the question as we're talking, right? This is kind of like a conversation. And so just imagine if you were having lunch with somebody, right? That you might finish chewing before you ask the question, right? But you would just pipe in and ask the question, would be raising your hand and getting in a queue. So jump in and ask questions. I'll start it off by just kind of asking them to kind of frame their experience, but then it's you guys. And then at the end, we really want this segment called AMA, right? That is not the American Medical Association. That is not the American Marijuana Association. It is Ask Me Anything. So ask our featured guests. I'm a little nervous to say anything again, but ask them anything, preferably about case process. Would be a good thing.
Just don't ask if they're a member of the American Marijuana Association.
Well, we do have the ability to mute, so if we need to do that. But before we kick into it, and then I turn it over and ask the kind of first questions to our guests, I just want to bring two resources to everybody's attention. Okay, so I'm going to share my screen for a couple of minutes here. So everybody should now be seeing something that says Pretrial 101. Somebody give me some verbal, yeah, no.
Yes.
It's here
Yes.
now. Yes.
Beautiful. So this, we just redid, it's a reorganized and updated the case processing core strategy page on JDAIconnect. So everybody knows when you go to the resource center, right? You go, this is your first page when you hit there. You can hit any one of the core strategies. So I just want everybody to be aware of the updated core strategy page. And I would be remiss in being a human being if I didn't acknowledge the person who worked the hardest here with me was Bart Lubau. So thank you, Bart, for doing that. So we got this page updated. So that makes our second core strategy page updated. Data a little earlier in the year was, and then the case processing page. We just turned it live, I think, a few days ago. And the other resource I want to bring to your attention is, again, on JDAIconnect, if you go to the training space, right, and you come to the e-learning courses, you click on the e-learning course and you're going to come to a page of all the courses and you're going to see Expediting Case Processing. That's a work product from the community of practice. So it seemed to me pretty relevant to make sure everybody was aware of this resource. So all the information that was taught in the community of practice is also now part of this course. So I encourage you guys, you know, I'm assuming you're here today not just to brunch, but also to learn, and you must be a little bit at least interested in community of practice. So I wanted to make sure you saw the in case processing. So I wanted to make sure you saw this. If you have further questions or, you know, have any problems getting to any of those places or aren't sure kind of the path, you know, if you're not that familiar with JDAIconnect, no worries, reach out to me or to Ari or to anybody at PJI and we'll do our best to help you get to where you want to go or where you think you want to go. Okay. So without further ado, I'm gonna go ahead and mute a couple people that I think might be making a little bit of background noise. So if you can mute yourself if you're not talking, I think that's probably a good thing, just so that there's that less of that background noise. But we want you to stay on camera and we want you to unmute yourself when you have questions. So before I go to my first question to Bart and get this party rolling with case processing, Ari, tell me what I have forgotten, because I'm sure there is something that I should have said that I did not.
You know, you nailed it on the head. You did it. And the Beth Opus Ray, perfect.
So I thought that was going to be her answer. I wanted that on recording, so now we can now move on to case processing. Okay, so Bart, I'm going to throw my first question to you, okay, as the faculty person. You know, of all of the areas of system reform that we could tackle in a community of practice on JDAIconnect, we chose case processing. What's the importance of that core strategy, and why should we all be paying attention to it?
Well, I think that there are a number of answers to your question, Beth. So we did the practice guide because we recognized that case processing was one of the core strategies that had been least addressed across the 300 JDAI sites. And the irony of that, of course, is that if we can find ways to process cases in a more timely manner, we can reduce lengths of stay in detention, we can increase the availability of alternatives to detention program slots, and we can also do things that are more consistent with what we know about adolescent development. And so we felt like this needed a booster shot. We needed to get sites focused on the potential that they could reduce their detention populations, even if they didn't reduce admissions, simply by moving cases along more expeditiously.
Beautiful, thank you. And then as a follow-up before we get to the site-specific questions and, you know, chat about how their sites experience the community practice and case processing reforms, what would you say are some of the typical barriers to effective case processing?
So first of all, and this is a gross generalization, but I think that the people on today's webinar will appreciate it. I think the biggest barrier to getting sites to focus on case processing reforms is that this is all about changing adult behavior. And I don't know about the rest of you, but in my experience, kids are much more amenable to change than adults are. And so I think the primary barrier has been that this really requires the adults to look at themselves in the mirror and ask the question, are we being efficient? Do we tolerate unnecessary delays? And what could we do better that would in fact reduce the time that you spend, not just in detention, but in the court system generally? So that's the general answer to the question. I think there are other problems, other issues that are worth noting. One of them is that even though most states either have speedy trial requirements that are in state statute or have court rules that imply how long it should take for cases to move from one decision point to the next, part of the problem with adults implementing those timeframes, whether they're regulatory or statutory, is simply that we come to view them as we view most deadlines as the desired point rather than the worst case scenario. So if you live in a jurisdiction where it says that a youth must have an adjudicatory hearing within 30 days, that court system is likely to see itself as being grade A, top-notch prime if most of their cases are adjudicated in 30 days, even though there's nothing sacred or holy about 30 days, and it begs the question of whether or not a considerable percentage of those cases could be resolved in 15 days or 20 days. So part of the problem is adults misinterpreting statutory time limits as being the desired outcome. Now, it's only fair to say to everybody who works in the system that there are also at times legitimate concerns about resources and whether or not cases can be handled in a more timely way given the flow of cases through the system. And I certainly recognize that that can be a problem in certain places. But the fact of the matter is that if you have a backlog of cases and it is not growing, then it means that the problem is not that you don't have enough resources to handle the flow of cases. It means that you don't have a strategy to eliminate the backlog. So you could figure out a one-time option to get rid of the backlog. Then those system resources are available to address cases in a more timely way. A simple example, let's say in your jurisdiction it takes 6 weeks to get a psychological report prepared and submitted to the court. Now, we all know it doesn't take 6 weeks to do the work involved in preparing the report. Typically what happens is that the cases end up in a queue, in a lineup, and they go one after the other. But if the lineup of cases is not increasing, and we could figure out how to deal with the backlog, then we could actually prepare psychological reports in the amount of days that it takes to actually do the work, not the days that we require because we have a backlog.
Hey, Bart, thank you. I think you're right. That was kind of like a quick, the practice guide is full of a whole chart of common delays and solutions. So I think that kind of helps us whet the appetite. So appreciate that. I'll turn it over to Shelly and Will, right? And then Amy too, please, chime in here, right? But really what I'm hoping that we could talk about is why did your sites, Douglas County, Nebraska, the state of Hawaii, and Shelby County, Tennessee, why did you want to be part of this case processing community practice? And then what did your sites get out of the experience? So I will flip a three-way coin. Shelly, you won. So you go first.
That works. And I think what I'm going to say is kind of a lot of what Bart was saying about the adults, but I think what it really comes to for us a lot of times is really ego. all of our egos. We were having a hard time getting along, hard time hearing what each other were saying, reacting to things from the different ways we sit in juvenile court and how we're serving the kids. And so we thought it was really important to do it starting as a team, to just get everybody to focus on maybe something else for a minute that we're not doing in our case processing committee, but just kind of hearing some information so we were all learning something together that wasn't really any room to argue about, if that makes sense. And it really, I think for us, do you want me to do the what we got out of it, or are we doing that second? Go ahead. And so for us, I have to tell you, I was really surprised. I was talking about earlier this week that I assumed what we were going to get out of it was relief related to our warrants that we've been looking at for many years. And we do have some relief coming that way that came from the community of practice. But oddly enough, the simplest little thing has made the biggest difference in Douglas County was the creation of a system map. We have had a few different system maps, one of which is 10 pages long since I started, and struggling through to make this one little page for me to be able to show community members. I've been speaking at our county board, and I told Beth the first time I went, I guess I was surprised. I assume everybody knows everything about our kids, right? But you forget, you go to the county board and someone's going to them saying, I want to turn my farm into a drive-in theater. I want to have the largest flag in Omaha. And there's so many issues they're working on that they can't specialize when it comes to our kids. And so having this system map for our politicians, I'm floored at how the light bulbs are going off and people are understanding this is about more than detention. The 4 years I've been here, we have 200 people working on the 70 kids who are detained. And it's like, what about those system points in front of us that are feeding us? Or can we do any reform work there? And so the simple system map that I'll admit, even when we were picked that as something to do, I thought, why do we do this? We have 10 of them already. And when this came out as our final product, has just opened up discussion all over our county in places that I really didn't see it happening. So that, I think, was our biggest benefit.
Somebody got a question? Okay, I don't want to steal anyone's thunder, but like in a Shelly and I, like she said, we were chatting earlier, and she said the exact same thing Bart did. This is about us changing, right? And so coming to the table, and in Douglas County, like Shelly, they couldn't get people to the table. So there's this, not just the system map, the simplicity and the exclamation and the points beyond and before detention, but getting people to sit down and talk.
And it's taken us to a place where now I almost want to whisper it until the vote is done, but I'll do it anyway. We now, after 11 years, are set up starting next month to have the county attorney and public defender be the chairs of our case processing committee. Probably should have looked like that years ago. They're the people in charge. We know it's an adversarial process. Let's see it, guys. Let's go. How can we help each other? Let's hear each other and meet our needs of ourselves so we can meet the needs of our kids.
Shelly, did you notice any pushback when you all started to, get the system map and then start to make these recommendations?
Yes, well, I've decided about that, Ari. We're all people who, when you do a job application or any kind of application, never need to leave a line blank, right? We're at least putting not applicable because we're not leaving it blank. So one thing that I think is really hard about this work is exactly that. You show 50 people this, 49 of them are attorneys, and you get 76 responses of what else could be added or changed. So, but it's just working through it, hearing people acknowledging what they say and giving them good reason why maybe you're not including something, or thanking them when they gave you something that you should. So yeah, it took a lot of going over from all the system points themselves too, to say, no, that's not how we work. We do this. And, but it led to really good discussion. And again, like I said, thrilled with what it's doing for education in our county.
That's great.
Shelly, let's get that system map uploaded to JDAIconnect. I know it's in the community.
Like, what is it?
I'm not sure if that person was meaning to talk.
It's Lenora.
Lenora?
Oh, no, I'm sorry. I don't know what I hit. I did not mean to talk. Sorry about that.
If you had a question, I didn't want to interrupt you. I'm sorry too. I was
But
just gonna
I
say,
can do that.
yeah, because Shelly, you probably got it in the community practice space, but that's that
Nice.
private. So let's get it on there.
Got it.
Great. So now let's go all the way from Nebraska to, I'm going to go to my right, which in some ways, that's going to be, I don't know, I'm going west. William, talk to us about Hawaii's involvement and what you guys got out of it. First, before you talk, I would acknowledge Hawaii. They just had a really successful state conference. So.
Yeah, we're beat from that 3-day conference. You know, much like Shelly was saying, we ran into the same issues. You know, we looked at, what we wanted to join was because when Bart, you know, first kind of presented this, we were listening to some of the issues that they were identifying before the community of practice, and we thought, wow, these are some of the issues we're encountering, and we wanted to find out how other counties, especially Amy folks, you know, how they were working on addressing some of these issues. And so that's why we joined. We kind of bit off a little more than we could chew because we run statewide, but within the state we have these different counties. And so we joined together with Hawaii County, which is the Big Island, and each county has a different prosecutor, they have different judges, they have different public defenders. And so we found that to be the first issue. So we looked at how can we separate out our counties while at the same time coming together to identify the issues that we're encountering and figuring out and trying to, you know, process how we can overcome those issues. And so much like, you know, Shelly folks, we looked at doing a systems map, and you know, Carol, our statewide JDAI coordinator, worked for weeks on that. And like Shelly said, it ended up being, you know, 10, 15 pages. And so we really had to condense it down so that we could understand, you know, where is our system going? How does the youth go from point A to point B? And really starting to identify where the issues are. And so we really looked at both the front end and the back end, because the middle was okay. The middle meaning once probation received referrals, there's already laws and court rules in place as to timeframes that we had. So we were really looking at when the youth is arrested to when we get it and how that works out and how that process works from police to us, as well as once we get it and it's filed and it's brought to court, then what happens with, you know, the delays in trials and case processing at the end before even adjudication and before probation even gets to do the work that they get to do. And one of the big things we're looking at is when we get a youth into court and the court process starts, what we started to find is the prosecutors were asking for extensions, the public defenders were saying, well, this wasn't ready or that wasn't ready. And next thing you know, the youth has been in court for 1.5 years, you know, with all these continuances, and the youth hasn't received a single service yet because they haven't been adjudicated. And when we found that out, you know, we really tried to look at how we can either put them on a diversion track while they're waiting for court hearings, or we got our judges involved, our senior judge, as well as our family court judges, to say, you know, really look at why we're issuing these continuances. And like Shelly said, it's an adult thing. Excuse me. And, you know, the adults are saying, well, you know, we're not ready or we're not doing this, and it's hurting the youth. And so really we're still digging deeper into how our judges can prevent these continuances from occurring, or giving the attorneys shorter timeframes so that we can really provide the services that these youth need, whether they're adjudicated or not.
Thanks, Will. A lot of work there in Hawaii.
Well, I have a quick question. When you were talking about looking at the data and like the trends over time, were you looking just at one county, or were you looking at big data from across the entire state?
We split it into 2 counties. So I'm in Honolulu County, and we have our Hawaii County, which is our Big Island, and our administrator there, Randy Cooper, has been working really hard at looking at the data there. So we kind of, you know, did 2 data runs separately, but yet we came together, you know, in the case processing group, and we really tried to identify what the different issues were in both counties.
And were you able to get support from the judge based on that data, or is it based on the relationships that you have?
I think it's based on both, and it really goes for all the adults, right? When you have data, it's hard to not be accountable to that data, right? I mean, most of the time, data doesn't lie unless it's garbage in, garbage out, right? So we really presented the data as this is the cold, hard data that we have. We even went down into actual cases and went back and said, okay, on this day, there was a continuance issued for blah, blah, blah. And, you know, how could we have prevented that continuance from lasting another 3 months before this youth came back to court? So data was extremely important.
And then Will, go. Will, didn't you guys also, like, right at the beginning of the community practice, or like maybe right after we started, you guys hired an expediter, didn't you?
Correct. So for 2 or 3 years before the case processing community practice started, we worked with BART to get a case expediter on board, and we hired one. Yeah, it was about a year ago, and we really tried to incorporate. So we included her in the case processing community of practice, and we really also tried to look at who's going into detention and why they're staying there for so long. And we did do a data run on that, and we found things like, you know, psychological evaluations are taking too long, or referrals to residential treatment programs are taking too long. And so our expediter did help to, you know, really dig deeper into that and get that data to show, okay, we had 100 kids, and of the 100 kids, you know, 40 of them had some kind of delay based on an adult matter.
Thanks, Will.
Can I just say, Beth, too, because Will's not probably going to say it, for any of you who weren't a part of it but are curious, if someone could tell me how to get there, Hawaii has some pretty cool ways to look at data. That's just kind of fun to look at, that opens your brain to different ways you can look at things, too.
Another compliment for Hawaii. Good. Love that, Will Maymore. So Amy was the on representing Shelby County, Tennessee, and I think most people know Shelby County. The state isn't a state JDI site, but Shelby County has done a lot of work, and Shelby County is the site in Tennessee that participates in JDI. So, Amy, I wonder if you would tell us a little bit about your experience in the community practice regarding Shelby County's case processing reforms.
Right. So we started doing case processing. I want to say I looked at 2016 data first. And so it was sort of to be honest, we didn't really know what we were doing. It was sort of we're going to make it up as we go. And Mark was generous enough to give me a list of questions that we wanted to kind of look at. And so that's where we started with. And those are that's how we ended up pulling the data. And we found from our standpoint, our major problems with kids staying in detention for longer periods of time had to do with psych evals, kids that were waiting on psych evals, kids that had motions of transfer filed against them, and those really kind of coincide with the psych evals as well, because if your child has had a motion of transfer filed, normally that child's definitely had some type of a pretty serious crime. And so a lot of the times the defense attorneys are going to request psychological evaluations for those particular cases. The other thing that we had an issue with is motions for discovery. The way that our transfer hearings work, and Chris, you can jump in if I'm telling you this wrong, but the way that our transfer hearings work is that basically it's a probable cause hearing. It's not a full-on trial, and therefore the motions for discovery are limited. And so we still have defense attorneys that like to file these motions for discovery, even though it's a limited finding. So they file the motions, we have to hear the motions, and that sort of elongates our process a little bit as well. Chris, is that accurate?
It's fairly accurate. The discovery motions weren't adding a whole lot. Can you actually hear me?
Yeah.
So I'm doing this on my phone, so my computer won't let me do it. It was mainly from my experience when I came over about 5 years ago almost now. It was psychological evaluations that were holding it up. And then because it was a serious offense, extra continuances to make sure that they covered all their bases.
Right.
So those were your two big areas. The discovery motions, there was some argument in there, but most of that petered out. It didn't add, it might add a few days at most.
So that's kind of where we were. Chris is our prosecutor. That's why I kind of put him on the spot there. But so we sort of, we sort of kind of got, I don't know, sort of grandfathered in by Mark. Mark was like, hey, will you do this? We did it. We came up with some really
Amy, not everybody probably knows who Mark is.
Oh, I'm sorry, Mark Solar, the director for the Children's Center for Law and Policy, who is our JDAI technical assistant guy, who I adore. But sometimes he drives me a little nuts with this case processing. So we have data now from 2016, 17, and 18. I'm getting ready to pull 19, but still sort of cleaning up 18 so that we can have some type of comparison. There is a graph, and Beth, I know you've got a copy of it, that shows the difference in our detention population between 2016 and 2017. And what we did do was we were able to decrease the amount of, we had a lot of kids that were coming in and staying for like between 1 and 5 days. What we were able to do was decrease that amount of children that were coming in and staying for very short periods of time. But in doing that, we also increased the amount of kids that were staying for longer periods of time, because we were able to get the kids that didn't need to be here out really quick, but we were having to keep the kids that did need to be here a little bit longer.
Yeah, the data that Shelly's talking about is in the course. We actually put it in our course to demonstrate the I think it's a length of stay distribution chart.
Yeah, that's what it is. The average length of stay distribution chart. It's pretty, I'm pretty impressed with it. Granted, it's my site, so I get excited about stuff that has to do with me, but I like the chart. The chart I think is really good. That's where we had some help with producing that chart. I produced a different one, but Bart was very helpful in helping me kind of get that together as well.
Amy or Chris, whoever wants to take it, do you all have any goals as far as reducing that time, like year by year, like, okay, we're going to get down to a certain number, especially for those folks who need more attention, or the cases that are a little bit more high profile or high risk, high need? Do you have any goals every year, annually, that you go in and say that we're going to make sure that we get those numbers down, or is it just kind of as you go?
It's kind of as we go at this point. I've had meetings with the magistrates and the judge regarding the length of time that psychological evaluations are taking, because that does seem to be a major sort of sticking point with us. So they have had conversations with the people that provide that information, and sort of trying to get it done at a quicker rate of speed, for lack of a better term. Chris, do you want to?
Yeah, let me add something. In Tennessee, there is a statute that allows for 30 days for a psychological evaluation. So even if the court wants to push it less than 30 days, unless that doctor agrees, they have 30 days statutorily. So that is one barrier that cannot be overcome, or would be very difficult.
You contract with those doctors, Chris?
We do. There's an internal doctor. There's also an external group that does these evaluations. Sometimes we can get them quicker. We can expedite from time to time, but overall, they're going to give resistance, particularly the outside ones, because not only do they do juveniles, they do the vast majority of the ones for the adult system, which, if you're familiar with Shelby County, it's a very large jurisdiction. 100,000 cases run through it. So we are somewhat limited there. We try to use internally when we can, because she is quicker. She does tend to expedite when she can. So she's aware of the issue and wants to work with us.
Well, I would think the fact that you contract with people for these is a considerable point of leverage, because the statute doesn't say you must give 30 days. it provides for up to 30 days, right?
That's true, but it's a county contract. So I think it encompasses not just the juvenile court, but it also encompasses all the adult courts. And with the volume of cases, it's only going to be so much leverage for the juvenile court. However, we try to do them internally when we can because that speed is much more quick. She's in-house, she has a contract, and we only use the outside source when we see her getting backed up. We use the internal first. If she's getting backed up, then we go to the external source.
One of the things that I think we should point out to everybody who's with us today is that this issue about psych reports was a major discussion within the community of practice, as it also is in the practice guide. And one of the things that we paid attention to in those discussions is the question of whether, in fact, we are ordering psychological reports in ways that may not help inform court decisions. So we do provide an example of a clinic in one JDAI site that actually have staff available to the actors in the courtroom when they're contemplating organizing or ordering a psychological report, to have a mental health expert actually go and confer with those folks and indicate whether a psych report is actually going to answer the question that they think a psych report is going to answer. And that has reduced the number of orders for psych reports considerably, and therefore the backlog that they were addressing.
If I could add something to that point from Shelby County, that was an issue that we had. When I first came down to juvenile court, my background being in adult courts, in every single case where a notice of transfer was filed, or in many delinquency cases, they were filing for orders. They were routinely granted, no matter what basis, if any basis was given. These were form orders. When I came over, it was taking us at least 60 days to get a psychological, maybe longer in many cases. I saw one as long as 90. Now we get our psychological evaluation somewhere between 30 to 35 days. If it's longer, it's because the doctor saw something and they needed more information and they're waiting on additional information from the school systems or another. So now when the attorneys come in, they have to have a basis to do it. They can't just say, well, because it's a serious case. No. Why do we need to evaluate this child? What benefit is it from? And that is dramatically cut down to the number of psych evaluations and the length of time.
Other questions? Nancy?
Yeah, I have a question for those of you who have done this work in, so in Indiana, several of our sites are doing case processing studies currently. And one of the things that we have been trying to get at is disaggregating by kids who've been in detention versus alternatives to detention programs, and those who are outright released. But what we're struggling with is sometimes kids come into detention for a period of time, and then throughout the pendency of their case, they get into an ATD and may or may not come back into detention or be outright released. So in terms of how we categorize those kids, like trying to compare amongst groups, we are, and similarly, if a kid comes to the door and then is placed in an ATD immediately, may go to a release status or to a detention status, again, until disposition. Don't get me wrong, we don't have, well, I shouldn't say, some of our sites have very lengthy, it's not like this takes a year to happen, but even within a 30 to 45 day period of time to dispose a case, they might go amongst those three categories. So just asking if any of you have a recommendation for how we might want to look at this, or should we not even be concerned about the differences between those groups of kids?
All right, so let me just tell you what, I'm sorry, Bart.
Go ahead, Amy, knock yourself
Okay, I'll tell you what we do. The kids I look at are specifically kids that have been admitted into our detention facility.
Okay.
Now, that kid may be admitted into our detention facility. He may get out the next day on an appearance bond or an electronic monitor or whatever, but I continue to monitor him until his case has been disposed. I've got a column that will calculate his length of time that he stayed in detention, but I also calculate the length of time it took from when he first got to detention to when his case has finally been disposed. So there's a whole bunch of different numbers that I look at. I look at the time that he spent in detention. I look at the time between each court hearing. I look at the time between the initial detention hearing and the final disposition. And so there's a whole bunch of different circumstances that I look at. We do have some children that will get released on an electronic monitor or just on an appearance bond, and once in a while they will come back based on that specific charge, on the same charge. So what I end up doing is that child will end up having 2 entries. He'll have an entry for the first detention stay, and he'll have an entry for the second detention stay. So we're going to look at the 2 different numbers of days that he stayed in detention on both different instances. But we are going to look then at the full case and say, well, from the beginning of his case, when it started, when he first went into detention the very first time, till the end of the case when he had a final disposition, how long did that take?
Okay.
So we kind of look at it in two different ways. I look at it, how many times has the kid actually been? So I might have a total of 245 cases to look at, but only at 235 kids. Does that make sense?
Oh, sure. So you're not necessarily comparing, though. You're not saying, okay, this kid was in secure detention, so we're going to compare those lengths of stay to this other group of kids who were on alternatives to detention, because there would be overlap.
Right.
Is that what I'm hearing? Okay.
Yeah, I just kind of wanted to focus specifically on the kids that were in detention and find out where our hiccups were there, because clearly we're concerned about getting kids out of detention. The kids,
oh, sure.
The kids that are not in detention, the kids that have been released on electronic monitoring or just on an appearance bond, they're on the next phase, I want to say, of where I'm going to go with the research, but that we're just not quite there yet. But it's on the agenda. I just haven't gone there yet because I wanted to focus specifically on one group before I tried to make comparisons between the other 2.
Okay.
So
I'd like to respond.
Well, I was going to say, we only have a few minutes left. So Bart, would you go ahead and respond? Because I could tell that you wanted to respond.
First of all, Nancy, kudos to Indiana as usual for getting down in the weeds. These are exactly the kinds of complicated questions that we hope a good examination of case processing will raise. One approach to dealing with the dilemma you're describing is to define discrete groups that you want to look at. So for example, you might start with, let's look at case processing times of kids who are at liberty while their cases are pending, and look at the times for that group if they've been at liberty through the disposition of the case. Similarly, let's have another subgroup of kids who are released to an alternative and look at the time frames that those kids experience, and then do what Amy did, is let's look at kids who are in detention. And you might even say, let's look at kids who are in detention from the time of first appearance through disposition. So we get a big picture of those cases that are the simplest to analyze.
Sure, okay.
Then you're going to end up with the kind of cases that Amy is describing, where a kid was sent to an alternative, screwed up, got put back in detention for a little while. But you'll be able to discern as you look at the data whether, for example, a failure in an alternative to detention program results in an unusually long length of stay subsequently. Now, some judges throw the kids back in detention for a couple of days thinking that it's a splash of cold water, and they'll realize that failure to comply with program conditions has serious consequences. Others will simply say, we tried you, you failed, and we're going to leave you that way.
Mm-hmm.
The point is, break your different cases out into different subgroups and try to understand the patterns within each.
Okay. That's great advice. I like, my mind already goes to, do we have enough in terms of a sample size within each of those that actually stay in detention the full time or stay, but I don't know that. So it's certainly some place to start. Appreciate it.
Shelly, we're going to give you the quick last response to this, and then we're going to have to wrap it up.
You bet. And I don't know if this is helpful, but I think whenever I'm looking, I always look at kids who are already serving on probation and kids who are new, because when I feel like when we are already serving this child, we have been in control of this for 2 months or 2 years, we should have plans for the minute they're picked up to put them right back where they need to be. So I think looking at them as kids who are already serving and brand new to the system helps too, because you start to see the kids where everybody's getting irritated and we don't know what to do and they kind of just sit there.
Yeah, and so far we have only included kids coming in on new delinquent offenses. We have not studied yet that those kids are like in for violations of probation. So that we just thought we would start small and build on that.
Sure.
So as we wrap up, I just kind of want to point out one other resource that I don't know if you guys get JDI Connections, but we featured the story of Dallas County in last week's Connections. And it was about the community practice and their experience and what they implemented and then the results. So I encourage you to take a look at that on JDI Connect. If you just go to the search and hit Dallas County, you'll find it. Or if you go to the case processing core strategy pages, on the page of the community practice, you'll see the Dallas story there also. And
Beth, I need to ask for one quick moment to fill in a blank that I left out in my original comments.
You are killing me, Bart, but I would never tell you no.
Thank you. So for those of you who are from sites that have not previously taken on the issue of case processing, and even those of you that participated in the community of practice, this issue is going to take on increasing importance over the next 3 years because of the amendments to the Juvenile Justice and Delinquency Prevention Act that were put in place earlier this year. Those amendments will require within 3 years that youth being prosecuted as adults who are under age 18 be held in local juvenile detention centers, not in adult jails. That means that if you're in a jurisdiction which currently doesn't keep its transfer cases in the juvenile detention center, you will have a new influx of cases, and they will not only be new, but they will be cases which will typically have average lengths of stay far in excess of what you experience in the juvenile court, simply because adult criminal courts have different speedy trial expectations. So it's time to get on this now, because it's coming at all of our sites, in fact, every juvenile detention center in the country. And it's going to complicate the challenge of expediting case processing even further, since the adult court system is not sensitive to the developmental reasons why juvenile court case processing is so much quicker than adult case processing. The opportunity for all of us is essentially to demand that a new set of norms be established in the adult system for kids being prosecuted as adults. But the main point I wanted to make is there's a group of cases coming into the juvenile detention centers over the next 3 years who may now be languishing in your local jail. And if that's the case, shame on your jurisdiction. But that's an editorial comment, by the way. But in any event, the implications for population management in your juvenile detention center will be profound, and it would be advisable to get on top of this quickly before that flood of new cases starts coming to you.
And luckily, you have a lot of resources on JDI Connect. So thank you, Bart. Thank you, everybody. Thank you, Amy. Thank you, Shelly. Thank you, Will. I'll go through all the names that were already done. So thank you, everybody, for taking time to join us for our first Brunch and Learn. Look for other opportunities like this on JDAI Connect, because we're going to continue to do the Brunch and Learns around different topics. And just to whet your appetite a little bit, there's going to be another challenge opening on June 17th on data. So we talked a lot about data in its relationship with court case processing. So check that out also on JDAI Connect. Without further ado, thank you, thank you, thank you. I appreciate it. Everybody's attendance. We all appreciate everybody's attendance. Reach out, continue the discussion on JDAI Connect. See you guys.
Bye, everyone.
Thanks, Beth.
Thank you, Beth.